very eminent panel for coming all across the world on a Saturday morning here in Bombay. And welcome. Why is cartel enforcement so important today, not just in India but across the world? Well, because it has the ability to impose the highest economic penalties in India. Penalties can go up to 10% of your turnover for every year of existence if you're in a cartel, starting from the 20th of May 2009, or up to 3 times your profit, whichever is higher. Has the CCI actually imposed any significant penalties, or is it a paper tiger? As industry and a lot of you who are already here know, the competition regulator takes a very, very serious view of cartels. Penalties have been extremely stringent. They've ranged across thousands of crores, with the highest penalty being 6,307 crores for an alleged violation period of about 18 months. So penalties are extremely significant. Now, before the competition regulator, whether it's the Indian competition regulator or global competition regulator, decides to impose a penalty for cartelization, what level of evidence do they really look at? Is it always direct evidence? Is it circumstantial evidence? Is it beyond reasonable doubt? And for this, I'm going to hand over to Drew.
Hi, good morning, all. Well, that's an excellent question. I mean, I think, we've been having this discussion in many countries more and more over the years. The U.S., along with Germany, really was one of the first true enforcers of cartel. Japan got involved very early, but recently, over the last 15 years, 20 years, there's been a continuing snowball effect, and so the European Union now routinely fines companies in the hundreds of millions of euro. The United States routinely fines hundreds of millions of dollars. China is now involved, Korea, and now we see, in the last 5 years, but really over the last 3 or 4, the CCI has also much more begun to have a robust enforcement mechanism where you have exposure to these enormous fines. Now, in some jurisdictions, these are straightforward criminal statutes, and so that's particularly true in the United States, also in Canada, the UK, a handful of other countries. People will go to jail. You have to prove things beyond a reasonable doubt. There's very, very strict judicial review, very close review by judges of everything, every piece of evidence. But in most jurisdictions, these are civil fines. And so things are generally being, the commission or the regulator will be required to prove an offense to a reasonable standard, a reasonable balance of the probabilities, a weighting of the evidence, or, for example, in China, there probably never will be judicial review. They're required to prove it to the extent that they want to believe it, and you're just gonna have it. But what that means is, what you have on the one hand are these truly staggering levels of fines that can destroy a company, that can destroy an industry. And yet you have on the other side a real spectrum of the type of evidence that's needed to lock in that penalty. And we'll come in a little bit to what India's position is. There is a presumption here, but it becomes very worrying when you have a regulator that takes legal presumptions designed to, let's say, save time and money for very clearly obvious things, and begins to expand them in a way that means that they don't have to meet that same level of proof. It becomes a shortcut. It becomes a backdoor to expanding things, and you begin to see fines grow and penalties grow where the evidence is not as clear and there's not as harsh, or I won't say harsh, not as stringent a requirement. The regulators in other jurisdictions, we sometimes see them get lazy, I would even say. So, if we start with the US, again, we're talking about a criminal jurisdiction. There are also civil penalties. But the U.S. has what's called a per se rule, and you often see people make analogies to that. There's a per se rule and a rule of reason. The per se rule treats things, strictly as illegal. The rule of reason looks to balance various factors. For sort of the four hardcore antitrust violations, the cartel violations, what are considered to be the supreme evil, as they've been called in the U.S., are pernicious, particularly pernicious price fixing, allocation of markets, bid rigging, and horizontal geographic or restriction of output. In the U.S., the judicial authorities a long time ago took a look at these and said, you know what, you're almost never going to be able to show that there was some pro-competitive benefit here, that you did something here that was good, right? We know from economic analysis, we know from the real world of business, that if you did one of these four things, it was bad. We know that. We know it was bad. We don't need to waste our time. We don't need to waste the court's time. We don't need to waste, Department of Justice's time litigating over whether or not it was bad. And so we're just going to call these things per se illegal. This, by the fact of their own existence, they're wrong. Don't come in here and try to prove otherwise. Then, for things that are in a more gray area, there's what's called the rule of reason, where judges and the regulators will weigh things and they'll say, well, were there actually benefits to customers? Did this agreement somehow create pro-competitive effects? Did it increase innovation? Did it allow, advances in technology and research? And they'll weigh things out. So the per se is not really a presumption. It's an acknowledgement that there are things that we just don't care about. We don't have the patience for. We don't want to hear about it because it is such a small likelihood that you're right. Now, the European Union, as it developed its system, it has an analog to that, but you should also be careful not to see it as exactly true, because the European Union does have true presumptions. And the one that's an analog to per se is what's called a by-object presumption, which means that under Article 101.1, there are certain kinds of categories, those four things we just talked about, which are so bad that it is generally presumed that if you've done these things, you're not going to be able to make a successful showing that, in fact, what you did was good. To the degree that that presumption is limited to, price fixing, market sharing, output restriction, bid rigging, that's a very easy thing to agree with. Even if we're talking about these very high fines, we know that there's almost nothing to do there that's going to get your company out of trouble. But what you start to see then are presumptions that sneak in to other pieces of the analysis. And that is what can really be damaging. So just to give a couple examples, and we'll come back to India and I'll stop talking. But there is, for example, even if you have a per se offense in the US, the government still has to prove that there was an agreement. That still has to be, clearly proven. And obviously, again, the balance that you have here is that when you have a cartel, people no longer write these things down. Now, in the old days, and I have seen boxes of documents that contain this, people used to very clearly notate who were at meetings and what they agreed to bid on and not agreed. And I think those days are mostly gone. Nowadays, people hide their cartels, and it's a very easy speaking point to say, well, because people hide their cartels, we as a regulator shouldn't bear that sort of burden. We shouldn't bear the burden of showing that every single person was at every single meeting and that this is exactly what they agreed. We need to have circumstantial evidence to allow us to attack these most pernicious of agreements. And it's true, right? I mean, it's inherently true. It's hard as a political matter to come against that. But where it begins to get into a gray area is, if you're talking about hundreds of millions or billions of dollars of fines that are in fact predicated on what was the duration that you were involved in the cartel, what were the specific products, and what were the specific projects that were rigged. In Europe, there is what effectively acts as a legal presumption called the single and continuous infringement, which allows the commission to sort of in a hand-waving way tie all of the alleged participants into a cartel with this idea of awareness. And, maybe you attended one meeting. Maybe they can show that you attended two meetings. They can't necessarily show that you ever agreed. They can't show anything else. You might still be brought in for a 10-year period. And that 10 period, if you imagine a fine being predicated on the amount of sales each year, you can see just this enormous expansion that can happen. So I think I probably have already spoken for too long on this, but presumptions, we need to be quite careful, because where the presumption is limited to, was this agreement of the types that are so bad that we don't need to talk about effects. That I think is a generally acceptable and okay kind of thing. I think, on face value, that's a lot of what is there a presumption that there was an appreciable adverse effect on competition for those 4 types of agreements? I don't think that's terribly controversial. But where you start to get into this area of what do I need to show that your company actually had an agreement, and actually had the intention to fix this price, to rig this bid. Was anybody there? Maybe they were in a different meeting. Maybe they can show that you went to the same trade association meeting. Maybe they'll just show that, you had 2 salespeople at the same airport at the same time. Those types of things can stand up in courts, especially where these legal presumptions operate. We've even recently seen the European Commission, in a rare example of a failed attempt, tried to run an entire conspiracy theory that all of the world's major banks had conspired because they had a joint venture. It was a legitimate joint venture. There's no question about that. It was an important public joint venture, that ran a business that was worth billions of dollars. And the commission, in the first instance, all the way through to the oral hearing stage, essentially said each of the banks had people who showed up at the board of directors meetings for this joint venture. You were all at the same meetings. We can prove you were at the meetings. And we think there was an agreement. So therefore, you must have agreed because you were all there, and we think that there was a bad agreement. And luckily, I think, after the oral hearing, realized that even, that was maybe too far to go. But you get into this very dangerous mindset with the regulators where, they'll take that presumption and instead of, maybe really doing the hard investigative type activity that you'd like to see to collect evidence, they simply say, well, people hide cartels, so we don't need to.
If I may add to this, Andrew, and I think you're actually spot on, but what in effect has happened is that the way you apply the law, how you actually define the substantive provisions, has a profound effect on what you have to prove. And as you move away from sort of the traditional cartel, the price-fixing arrangements where you actually had to provide proof that people sat in the same smoke-filled hotel room and decided what the price of a certain vitamin would be, you nowadays have a much broader concept of what constitutes a by-object infringement. And sort of information exchanges are sort of I think the best example for this. You don't actually, the offense is not to fix prices, but the offense is to exchange confidential information about your pricing policies, and that in itself is the infringement. So, and that has, even if you apply the same standard of proof, because the facts that you have to prove are so much broader, it's much easier to actually show there's an infringement. And so actually by manipulating the substantive provision itself, you actually have an effect on sort of this topic. No?
I'm going to ask Kanaya, why is it that the Indian Supreme Court, with double decimal digit points across a bid, said not enough evidence for a cartel?
Well, to this context, I heard Dhruv and Mark about presumption and cartel evidence. And in this context, Indian Apex Court has some deviation here, because in one of the case of consolidated committee also they says that agreement is not to be presumed. It has to be proved by regulatory authority. So existence of competition, existence of agreement is precondition for presumption. Presumption is about appraisable adverse effect. That is to be presumed, and both these two have to be proved by a regulatory body. This is something I would say a little bit deviation compared to a global standard. And second, about bidding for these evidence, circumstantial evidences are not enough. Recently, Rajasthan LG cylinder gas case. And this is a very good judgment, I would say, because this is the first judgment in country today on economic law where Apex Court has traveled to the business area. It says that standard of proof or evidences required, it depends upon many economic factors of market conditions like demand, supply, like your oligopolistic market, oligopoly market, and existence of competency. Competition is the first thing. If there is no competition is not there, then what? So you have to first structure the market. So as per the market conditions factors, one has to apply the standard of proof. So this is a very vital point has been given by Apex Court. Otherwise, you can't apply the, paint the wall with the same brush here. So circumstantial evidence is required as per the market conditions and structure, number one. Number two, minimum bare standard required. You cannot have a lowering the standard of proof, having cherry-pick circumstantial evidence and, penalize heavy penalty. So that also judgment has come up very clearly. And one deviation I would say, if we have not noted so far, Nisha, everybody here, that we have all the bidding cases so far, which has traveled up to the Supreme Court. Not a regular pricing cartel case has traveled and completed the journey. So I think lot has to see. Let us see how this Apex Court is interpreting this standard of proof. But what are the today Apex decisions are there in the table? I could say that lower standard of proof is not acceptable. Even circumstantial evidence is not acceptable, like in case of wood pulp. They have gone only by circumstantial evidence is cherry pick, which has been turned down subsequently by European Court. So same thing here. Balance of probability, strong proof is required if the penalty is high. You cannot have the heavy penalty and lower standard of proof. So that is also maturing day by day. But one more point I would say from the Indian regulatory perspective is that quality of the investigations, and if I am the investigation officer, how I will handle investigation I can share with you. I don't want to go for circumstantial evidences, behavioral. I will directly go for downgrade, because direct evidences are available in hand. Why should I go apply my all expert mind behind that behavioral circumstantial evidences? Just go and attack the computers and forensic, and that's the way. And I'm jumping gun, but that is going to happen very soon, very fast. So this is one my take about this.
Thank you. We're now going to move on to our next topic, which is down rates. For the longest time, the Indian community, the business community, as well as the competition bar, was under this delusion that the Indians will not tell on each other, right? We will simply close ranks and deny the existence of a cartel. We're not going to come forward as a whistleblower. We've had on the books a leniency regime right from the time the statute has been enacted. But It's only recently, in the last few years, that we've seen a tremendous uptake in the number of leniency applications as well as the leniency decisions which our regulator, the Competition Commission of India, has come out with. And the most interesting thing is in the rest of the competition world, leniency is going down. In India, it's only going up. We currently have over 100 leniency applications with the regulator. Surprisingly, half of these are Japanese. So I'm going to hand over to Shimada Sensei to explain to us why is it that the Japanese are driving our leniency regime.
Thank you very much for a great introduction. I came from Japan, and I've been working in this area since like 15 years. Japan introduced that leniency regime in 2006. As Nisha said, that in Japan, the same norm was shared. Nobody would, cheat on your friends, close tie in the society, Japanese people. But once the day start, there are a lot of leniency. Actually, I was one of the kind of starters. There are a lot of leniency applications, and after that, as you may know, there are kind of festival of cartel based on outbursts of Japanese companies. So, and the Japanese people are very serious. So they are really kind of diligent in applying the leniency application in many countries. As Tanisha said, that recently it is a real question that should we really push for the leniency, because that there's some procedural point and as well as a substantial point is not always better off for the company, in kind of entire scheme. For example, like civil litigation, especially in the U.S., or the treatment of information submitted to the authorities, is that should be treated confidential or not. Also, it's very difficult. So, generally speaking, the kind of a trend, the companies are now more takes time to consider whether we should go for the leniency once that the things had happened. It is not politically correct to say that right here, but it is right. So it is interesting to hear about that in India. The leniency application is going up, but some years ago, or probably 5 years ago, Japanese companies are all really, we always advise their clients that you should go first, leniency. You should go. But now it's a little complicated. And given that, now that authority is really keen to, increase that number of leniency application, because now the leniency is almost the only source that they can use for the, starting investigation. So, interestingly, Japan has some kind of unique leniency system. Cooperation does not matter. Only the time, how fast you send a facsimile to the JFTC is only the matter of, factors. That is our system. This is very transparent and predictable, good for the companies. But of course, for regulators, it is not good because the first the first applicants, it's a kind of small company and they don't have any, the vital evidence, but still they should be 100% exempted. And the second one and third one, at a larger, major applicant, but how much do they, contribute to the investigation? They only can a reduction like 50% or 30%. So this week, or 2 days ago, on the 12th of March, the Japanese government announced that the new leniency system, it's more similar to the EU system probably. The corporation matters, the basic, the reduction rate plus that the reduction rate subject to contribution. But here, the next point is very important, is how to evaluate your contribution to the investigation, how valuable that the evidence you submitted is not an easy thing to so in that sense, we need to learn from a lot from other countries, like especially you. So.
Well, thank you. Perfect handover. I would actually like to add to this. Leniency as a concept seems to be fairly straightforward. You uncover illegal behavior, you write it all up, and you send a letter or fax to the authority, and maybe you have to cooperate throughout the procedure. But it doesn't actually sound complex as a concept. Now, I think in reality it's slightly different. Unless you're a one product, one market, one geographic market company, the question of whether to actually go for leniency actually involves a lot of factors and taking into account a number of very different elements. Firstly, there's more and more competition laws in this world. I think we've got about 120 odd countries with competition laws on their books. So if you actually have an international business, you may affect competition in a number of places. And the number of countries involved can be much broader than the countries you're actually colluding in. We've seen this, I think, with computer screens that were sold in one country, put into a computer in another country, and then shipped to a third country, and the third jurisdiction actually considered itself to have jurisdiction over a cartel that concerned the input product. So a potentially large number of jurisdictions to cover, which means that the effort of writing things up, of actually engaging with authorities, and in particular, if you have a continuing obligation to support the investigation, even in a single cartel, it can actually require significant resources and significant time. It's not just actually having to pay your lawyers to do it, but it actually does involve internal resources as well, because you have to actually go back, you have to look for the evidence, you have to engage with management to line things up. And even if you decide that actually the pain is worth, the effort's worth the pain, it becomes even more complex, because if you have more than one product, chances are that you may have a problem not just with the one product where you uncovered the illegal behavior, but with other products that you don't really have on your screen at that point of time. Now, if you go in for leniency in one or more jurisdictions, your competitors are put on notice. The authority will start an investigation. Your competitors, the people you colluded with, will also start their internal investigations. And what I think it's not just sometimes, but actually fairly often happens, is that these competitors of yours then realize there's not just a problem with product A, which you've gone for leniency for, but with product B, C, and D, right? And they then may decide to actually, swallow the bitter pill, having to pay a fine for product A, but actually getting even and more than that by applying for leniency themselves for products B, C, and D. And all this is something which, as a lawyer and as an in-house lawyer, as well as an external lawyer, and ultimately as a business person, you have to take a decision whether you can actually calculate the risk and whether you're willing to take the risk inherent in that particular circumstance.
Yeah, I think that's right. Obviously there's a quite clear risk-reward analysis where if you're talking about a $100 million fine and you're talking about some of these very high burdens in meeting a leniency requirement, especially a continuing cooperation requirement like they have in the EU and many other places. That makes a big difference. But I do want to say, just shortly, one of the things that you can't lose sight of as a regulator is that leniency programs are really built on trust. And if a regulator is not scrupulous about how it runs its leniency program, it will not create the faith in the business community to use that program. And so, we see an enormous difference in the types of leniency applications that are made in the US, where people respect the Department of Justice, I think, as quite a transparent and reliable regulator, versus China, which is just sort of getting into the leniency game, but they've had leniency programs for almost 10 years now. They're very seldom used ahead before an investigation starts, because, first of all, they had two different agencies with two different programs, which created a lot of uncertainty, and uncertainty is the last thing that you can have for a leniency program. And they also arrogated to the regulators the same type of discretion that the Chinese regulators like to have. Basically, they said, well, here are the leniency rules, but here's also, the catch-all for provisions that let us do what we want to do when we want to do it. If a regulator is unwilling to put into writing quite clearly exactly what it's going to do in all circumstances, it is not possible for the business to make that calculation about the risk and reward, and people will not use it. And if people don't use it, regulators are going to have a much harder time uncovering cartels. So for all that to be said, the regulator really needs itself to be cognizant that it has to build that level of faith with the business community. And if it doesn't have a successful program, it will not be able to stop cartels.
Mark, I have one question for you. In India, we faced a bit of a problem in the leniency regime in the earlier days until the CCI recently amended the leniency regime, where if I am acting for someone who is not a leniency applicant, right? So basically, I am not the leniency applicant. My client says they are not in the cartel, but the leniency applicant has come forward and said there is a cartel. There are two leniency applicants. Both have said they're part of the cartel, and they've said I'm a part of the cartel with them, because our leniency regime requires that the Competition Commission has to protect the identity and the information provided by the leniency applicant. I then have to go in and defend the client on a basis on which I don't really know, because everything that is given to me effectively tends to be redacted. How is it that Europe has resolved this issue, given that you all have had a head start on your competition regime?
Well, I guess the issue sort of does remain the same ultimately, and it is sort of crucial, having actually access to sort of the leniency applications and to the documents that are submitted with the application. I've just had a sort of a very rare case where actually my client was part of the cartel, allegedly, and a leniency applicant had come forward and identified the client. And it was only after sort of reviewing the evidence and being able to show that sort of the telephone calls that the leniency applicant had claimed to have happened didn't actually happen, because there was evidence in the applicant's file that showed that exactly my client hadn't been called, as was alleged in the application. So access to that file is important, and it's a key element of your right of defense, I would have said. But Andrew, going back to your point about the need to build trust for leniency programs to be effective, I think that's actually a key element. I would completely agree. If there's uncertainty as to how it is handled and about the conditions that apply, to your being granted either sort of 100% reduction or a certain amount of reduction. If there's uncertainty in that regard, it's a sort of serious disincentive to use the program. Because one thing that the client actually do look for is certainty. I mean, they're willing to pay for it. Leniency doesn't come for free, and there's all sorts of other unpleasant things that sort of it gives rise to, civil damages, that sort of thing. And the one thing that actually works in favor of these programs is that, at least as far as the authority is concerned, you know what you're in for. So that's a key element. But even if an authority is actually successful in doing that and creating a regime that's effective, it's a bit of a blessing and a curse. And it goes back to sort of the initial point we discussed about standards of proof. Because what leniency, at least in my experience, has done to authorities is to present proof and evidence to the authority, which, unlike the old days where they actually had to go out and hunt for that evidence and use skills that related to the uncovering of evidence and to the assessment and analysis of evidence, these days the authorities are basically handed it on a silver plate, which, interestingly enough, if you look at the cases that then make it to court, it's very rarely about evidence. It's more about legal concepts, privilege, the right to be heard, how far a cartel prohibition actually reaches, rather than evidentiary questions.
Our next subtopic is a very interesting one, compliance. What is the cost of compliance? What if you're not on the competition regulator's radar? Do you still invest in compliance? What happens if you invest in compliance and subsequently the regulator discovers that there is a violation? Is that compliance then held against you as only being paper compliance? Or is it held against you that you don't have a compliance policy in place and therefore the violation happened? Handing over to Mark on this one.
It's an interesting starting point, Nisha, talking about the cost of compliance, because as a matter of fact, it is often raised by clients. They see you as a lawyer, whether in-house or an external lawyer, approach the business and talk about things they have to do. And it takes time, it takes resources. People need to spend time in training sessions. You actually have to pay people to come and do the training, or have to have internal resources to do it. So it's sometimes seen as an expense, to which my reply would be, it actually isn't. It's not an expense. It's an investment, and it is an investment that should actually be a natural part of your business. And that actually sort of brings me to my conclusion straight away. If you just do a compliance program because you think there is a legal box to tick, you're unlikely to be successful in doing it. And that's actually sort of the second answer I would give. The first answer is, do you know how expensive it is not to have a compliance program? But the second answer is, the expense doesn't actually matter. It's sort of the question of, is this something which is truly at your heart, at your company's heart? Because a compliance program, in order to be effective, must reflect the way business is done. If you just sort of have a list of do's and don'ts which you hand out to your employees, you're unlikely to actually sort of have a lasting impact. It is only when you sit down and actually talk with them rather than talk to them, and try to understand how the business works and how it can be made antitrust compliant, is that you capture people's attention to the extent necessary to make a difference. And a key part of that actually is having management buy in for this. If senior management doesn't support not just the antitrust compliance program, but the notion that this is how we do business, the program is likely to fail at key points. And so I think that is, thinking about how to structure a program, a key element. Keep it simple, keep the legal language out, talk to people in business terms, make them understand that antitrust compliance actually is good for business, and get sort of the management, senior management in particular, to buy into the concept and to say, yes, it's not just, we want you to comply with the law, but it's about how we want you to run the business. That's the, I think, crucial element in setting up a proper program. Now, even the best programs fail, either because people don't pay attention, perhaps, or because you do have the rogue employee who likes to cut corners and get to their bonus in a more straightforward way than would be sort of otherwise the case. And so the question is, does having a compliance program have an effect on your position in an investigation? And the natural reaction of competition authorities, and one actually cannot blame them really for it, is to say, look, guys, you've had training, and still people did it. So surely this must be sort of making things worse for you. The good news is that it usually doesn't. So you don't get sort of an extra fine for having a compliance program. On the flip side, and still breaking the law as a company, on the flip side, companies tend to come forward and say, look, yes, we've had this employee, but we've also had a compliance program. And so, shouldn't we be let off the hook? Because, frankly, we did everything we could, to stop it from happening. And there, unfortunately, the answer regularly is no. Some authorities do grant some rebates. I think the UK authorities do that. But only for compliance programs that are effective, or at least, up to a very, very high standard. So just having something that's a piece of paper that people keep in their files, even for those authorities that are willing to grant reduction, won't really help them much. And thirdly, I think for individuals, and this is where sort of a compliance program may be most effective, for those countries where you have individual liability, having been trained and still breaking the law, that will sort of make a real impact, and because of course they knew what they were doing in a qualified way, and so for them actually it should be sort of a deterrence factor.
Thank you, Mark. Now handing over to the industry perspective, where we're very lucky today. We've got Kanaya, who is part of the world's largest cement company, and what global best practices he adopts, in addition to marrying it to local customizations, and we're going to hear from him. And then I'm going to hand over to Kaizad, who's the GC of Glenmark, which substantially exports to a number of other countries, right? So he has to look at compliance domestically and outside India. How do they do it, and so successfully?
Without repeating what Mark has already described, excellent way of compliance program and need of that, I would like to separate this competition law in its uniqueness compared to other compliance requirement. And this is very interesting to GC community here. Show me the single law in country today wherein burden of proof directly lies on you. Presumption that you are guilty. Show me the single law. The only law is competition law. Correct? Now, having burden of proof on me that I am innocent, then I need to have compliance program like independent pricing mechanisms, documentation rationale, all the process, decision-making process, And without having all these things in your side, you won't be able to prove, your discharge your burden of proof. So this is one strong, valid reason why competition law strong compliance program is required in your organizations. And this will easy for you as a GC to convince your CEO and MD that why compliance program is required. And I'm answering what Nisa has raised the point, is it cost or is it investment? This is certainly more than investment, because if my profitability is yearly 1,000 crore rupees, if I keep on paying the penalty every 3 years, 1 time, 2 times, 3 times, whatever, it means I keep on earning and I keep on investing that money in penalty. It doesn't make commercial sense also to do the cartel and have a strong compliance program, number one. Then I'm going back to the general mindset of the compliance. Business community thinks that compliance is a hurdle for the business. Now, it is up to them to decide whether they want to do the business, simply do the business, or sustainable way of doing business. It's all up to business community. That case study you have to demonstrate to your CEO and MD that how it is beneficial. Number 3, and then we have one more arm in our kit, is individual liability. The moment you go to your management and say that, look, you are achieving your profit, your EBITDA target KPI, and you are getting salary and bonus, but prepare to go to jail also one day if you do these things. And then look at the change of behavior. And this is everywhere. When it comes to individual, you have to be, one has to be react very different way than what is an employee. So individual liability, of course, we are lucky enough that in India we don't have criminal liability so far, but individual penalty is also a heavy one and reputation issue. So these are the various reasons and analysis you have to adopt and demonstrate successfully and strategically to your all business partners that why compliance program is required, and not only tick box exercise, it should be genuine and behavioral pattern. There should be consequences management for this your compliance program. You can advocate your HR department to have a KPI at least at a certain level of marketing behaviors in a market, KPI, link that with KPI, and I would say certainly there is a benefit about this program.
Yeah, so I think most of the points are covered by Mark and Kanhaiya. I don't know what to add more to this, but the only thing which I think is of relevance now is that under the law, currently today, the way in which the Section 48 of the competition law is, it says that, if you have contravened any of these provisions under the law, the only saving grace which is stipulated under the law is that you have taken adequate preventive and due diligence steps. Now, I agree that this law today does not really give much of protection. But I think over a period of time, this law is going to evolve. And I think companies and individuals, I think, first of all, as far as individuals are concerned, it certainly comes to rescue from a individual liability standpoint. And, although criminality is not there, but in certain jurisdictions, criminality is there, and it will certainly come to rescue if you have demonstrated that at an organization level, at a management level, tone from the top is to ensure compliance. Secondly, I also fully agree with Mark's point that compliance cannot be a tick mark exercise. You have to build in compliance, need-based compliance for your specific functions. Now, it cannot be a single formula which has to be adopted across the organizations. For example, if it's a tender business, the compliance level is far different. And I also believe training is so critical. Most of the time, people bump the line because of ignorance. I think if proper training is provided, if proper, there is a proper program and you have explained why and consequences that would follow if you behave in a particular manner, I think it goes a long way. I think overall, for an organization, it is important to be compliant.
Just a quick sort of point to add to your the final remark that consequences must be part of the system, because that actually I would subscribe to that. It is true. If you break the rules, then sort of something must happen as a consequence. Now, there is a certain tension between that, perfectly legitimate, and I would have thought, actually sort of a very sensible requirement, because you're not credible if there's no consequences of not adhering to it, and the situation where you realize that something has actually gone wrong. Because in that situation, it may well be exactly the same person whom you threatened with consequences under your compliance program, whom you will have to rely on to put together your leniency application if you decide to go for leniency. And it's a tension that I think is not easily resolved, but is there. And in a way, when you decide to have a leniency program and you start to think about what it should look like, that's part of the thought process that needs to go into it.
Just to address a small comment about consequences management and leniency program, I fairly agree with you that opportunity should be given to the employee before taking any consequences action. But Mark, look at the holistic situation. In organizations, you have the whistleblowing policy. As an employee, it's your ethical duty as well, if something goes wrong, to escalate it by way of whistleblowing and have the protection over there. So having said that and having that mechanism in place, still you prefer to do, and after having robust training programs and all, training awareness and all, despite that, as a last resort, nothing remains but consequences, then I'm talking about consequences and not jumping the gun at all.
Yeah. I guess my point would be to probably keep your options open. The awkward moments I've seen have been in cases where, with US clients who are very strict about these things for obvious and good reasons, they uncovered sort of a cartel, or actually someone else did it, went for leniency, so they got down-rated. They realized there was a problem, and sort of their automatic termination policy kicked in, and the fellow responsible for the business was dismissed. Now, they actually then had to employ this person because that, as a consultant, because that was the only way they could sort of actually get their leniency stuff together. So, in that sense, you need to be smart about how to handle it.
Our next topic is dawn rates. In India, we have this concept of Atiti Devo Bhava, which translated is the guest is God, right? The guest is very unwelcome when it's the Competition Commission knocking at your door and deciding to raid you on the basis of a search warrant. We've had effectively 3 raids in the fairly recent past, 2 of which have been based on leniency applications, which include the battery case as well as the current ongoing beer case, right? In light of this, I would hand over to Shimada Sensei because she had some very interesting facts in relation to how often the Japanese competition regulator conducts dawn raids, because we see one every 2 years, which is very low by global standards. So Shimada Sensei, please.
Thank you very much. So yeah, there are a lot of differences. I mean that in Japan, actually the JFTC, Japan Fair Trade Commission, is heavily relying on that downloads. Probably they like that, actually, I think, because that almost, that the most frequent day of the downloads happen is Tuesday, because that they need a lot of staff, and they will gather the staff from across the country, and they will travel to Tokyo on Monday and had to train, and sometimes they're leaking to the press, and then they will go to the company on the Tuesday morning, 9 a.m. And that down rate is often, on the TV news on the noon. It is really very often the frequent things that in the Japanese society. I heard that in India there are only 3 cases in a down rate in the past, and 1 case in 2 years, but probably in Japan it's like every 2 weeks. So and how that happens, I'd say that the JFTC is relying on that the information that they directly collected from the company, and and they don't have much kind of sophisticated rules of that. They seizure the original of the papers, the corporate documents, not copies actually, and they allow you to make it a copy, but it takes time. So basically they will get everything, and also the emails and the PC documents, etc. And at the same time, they will make an interview, the position of the key employees, all of a sudden. And in Japan, that such kind of interview is not unattended by the lawyers. It is not allowed. So, and also, well, probably I'm complaining about the Japanese system. The one thing that, we didn't have that attorney-client privilege. The JFTC did not recognize it. So they basically, they go to the legal department of the corporation and got that stuff, all the communication between us and the clients. But of course, that things has been huge criticized by the legal community and also international community as well. So last week, they announced that very limited but little development, the policy that they will admit the attorney-client privilege in really kind of limited scope, which is just limited to the cartel only. Not for the dominance case or not for the vertical case, but only cartel only. But it's still, it's not yet fixed. It should be going to diet and, that need to be approved. In any case, that how to conduct a down raise, is very kind of different from country to country by kind of sophistication, and that how much that down rate is important for the investigation in this leniency era. It's also kind of changing, and the case that, for example, 5 cartelists there, and 4 of them have making the leniency applications, for example, but still the authority would do that down raise, but 4 out of 5, that's also mock. That's just play, and that would that real kind of meaningful? I don't know that, but at least in the Japanese society, that making a down raise is a role to let the society knows that these people did the cartel. That's a huge impact. Before they going to the court, before the investigation, but this is all kind of publicly reported. So probably this kind of situation is kind of different in country to country. So I would like to ask you that. And you?
So Drew and Mark, we've heard from the international competition community that in Brazil there's been an instance where a very senior level management person ate paper when his company got down-rated, right? In Canada, we've heard from the Canadian Competition Bureau that one company decided to flood its basement, and then the Canadian Competition Bureau were Wellingtons and went in, waded through the water, and got whatever they needed to get, right? So could you give us examples from the US and EU of things that the GC community sitting here should be aware of what not to do in a dawn raid?
Well, I mean, my own personal experience, the thing that came to mind was one of our cement clients had been raided in Spain by the authority, and one of the people grabbed all of her papers from her cabinet and a USB drive, and she ran down to her car because she thought she needed to get everything out of the building. And then as she was driving down the highway, she started to throw things out of her car. And we did advise them that this probably was something that they should have covered in their compliance program, that this was not necessarily an effective way to preserve the confidentiality of your information. And then in China, we had a similar situation to Japan, where there is no attorney-client privilege, and people, essentially show up. I think the most common things we hear are people who believe that if they get something out of the workplace, it'll somehow be immune to, to uncovering by the authorities. And we certainly have lots of evidence in the U.S. and China and other places of people showing up at your door at 11 p.m. with a warrant, or at 6 in the morning, and they will come right into your house, come right into your personal computer, and just take it. And that's another thing that, in terms of compliance programs, you really need to make sure people are aware of that. You need to make sure that your in-house legal team is aware that these things can happen.
And the horrible thing is, it's actually when they just show up without a search warrant in the U.S., they ask to be let in, and if you do actually let them in, you've consented, no? Whereas, no.
Oh, I was going to say in China they don't ask.
Yes. Okay.
In the U.S. they do. I mean, in the U.S. they like you to. Don't you want to cooperate? Don't you want to help? Don't you want to be helpful? It would be much better for you if you,
And of course, it happens in a context where sort of the individual may react differently from the way he or she would act when visited in the office, right? I mean, you have your kids on the couch listening to dad talking to the police. That puts a lot of pressure on you.
It's hard to maintain an air of authority when you're staying there in your bathrobe.
Yes. Well, perhaps the one thing, talking about dawn raids, and I completely agree that dawn raid behavioral guidelines ought to be part of any sort of good compliance program. Because one of the things that used to happen in the old days was when people realized sort of the authority came knocking at the door, they went to their filing cupboards and sort of put everything into the shredding machine, which kind of saved it from going to the authority, but also meant that the company was actually blind as far as the future sort of investigation was concerned. So the idea is not to throw things away, even in jurisdictions where throwing stuff away may in itself be illegal and prosecuted as obstruction of justice. But to actually manage the situation properly. And what we're seeing is actually that when there is a dawn raid, and many dawn raids are, I wouldn't say done pro forma, but they're also used as sort of an advertisement of the fact that an investigation is going on. And when in Europe the agencies come, they will present you with a search warrant, and they will also hand you a copy of the leniency guidelines. Exactly, it is one package that they prepare for the company under investigation. And so what usually does happen, in Europe you can have lawyers present, and they will usually wait, but not very long, for lawyers to turn up. But what usually happens, at least with more sophisticated clients, is that you actually have two teams. One team that shadows the investigation and the officials doing the dawn raid, and the other team that actually meets in the boardroom and starts to work on the leniency application, or at least, sort of think it through and consider, sort of do the strategic thinking. So these things happen in parallel.
Yeah, that's so important, That's a really time matters, Once that the downloads come, that you should, if you are considering a leniency application, you should go first. So that's really important.
The big change we've seen in India has been individual liability. Again, it's been one of the things which has always been there on the statute books. But over a period of time, what has changed is who the commission is going after. In the initial days, it was the sales and marketing force. Now we see them going up to board level, promoter level, MDs, CEOs. This has been a big game changer in India, and it's something as GCs in terms of risk assessment, that's effectively your highest risk assessment. So handing over to Kaizad on how he sees the evolution of the Indian law on this point.
Thanks, Nisha. I think firstly what I would like to say is that under the Indian competition law, and the way in which the CCI has taken this particular event and held people individually liable, the thresholds have been very, very low. I think that's the first point which I would like to make. Under the law, every person who is who's responsible for the business, there is a deeming provision that if there is a contravention, every person is deemed to be responsible and he's deemed to be liable for having contravened that particular law. So under those circumstances, I think CCI has most of the cases which you see, CCI has held under the cartel cases, held individuals liable, and huge penalties have been levied. As you rightly said, initially it started with individual small departments, sales and marketing, but now things have gone up to the CEO, and the senior management teams are also made responsible, and huge penalties have been levied on them. I think these matters have been argued at the High Court level also, and one of the points which came about before the High Court was that the proceedings against the company vis-a-vis individuals should be separate. I think that's been disregarded. The High Courts have said that no separate proceedings. This is individual single proceedings which will go on against both these entities or both these individuals, if at all, company as well as individual. The other point which was argued was that under the competition law, the penalty is levied on the turnover. So therefore, how can an individual have a turnover? I think even that point has been disregarded by High Court, saying, the turnover has to be calculated looking at his income tax returns, so on and so forth. I think it's pretty harsh, and I think considering that huge penalties are levied on individuals, it's a big risk for individuals, and they need to put their things in order. And therefore, the compliance program, as we said, is a must.
Mark, question to you. In terms of D&O insurance, are the individuals covered?
Well, if they acted intentionally, of course, it always depends on the terms of your insurance policy. But I think in general, negligence is required for the insurance to kick in. So this might be the case where you have organizational issues. And then the question is, have you done everything to put into place a compliance program, and was the compliance program good enough, et cetera, et cetera. But where you have intentional infringements, i.e. the people who actually sat around the table fixing prices, then the insurance won't kick in. But it is, the spotlight actually does go on the individual, because in a way, competition authorities seem to have understood that you can appeal to the undertaking as such only to a limited extent, right? It will always be individuals who take the decision to go wrong and to do something which the law doesn't want them to do. So I think it's actually for the obvious reasons that individuals are targeted. And it's also obvious that you try to get as far higher up as possible, because ultimately that's where the changes occur, right? And a specific infringement will happen probably at a fairly low level. But the changes which you try to bring about with a penalty, the deterrence effect, that actually kicks in at a much higher level and requires intervention at a higher level.
I just want to ask, Mark, that in India, the Competition Commission has gone beyond imposing penalties. In certain cases, they have deassociated the office bearers of a trade association from holding offices for 2 years. And also under the Indian law, certain other laws would trigger in, particularly for directors and CEOs. If individually they have been held liable, then at the time when they are to be reappointed, they are supposedly disqualified. So I just wanted to understand in Europe or in other regions whether the competition authorities, the regulators have gone beyond imposing individual liabilities, penalties.
So, Mark, to clarify and add on to what Kaizad has said, the threshold currently under the Companies Act for disqualification of a director in terms of initial director or even reappointment is $15. $15 penalty under the Competition Act, 1,000 rupees.
Yep, that's a parking ticket, right? It depends on the rules of the country that apply to you. The UK, for example, has similar rules, and at the time, I think it was the OFT still, Office of Fair Trading, did impose disqualification orders on company directors. So that may actually happen. And you know, I think it is very important to understand the impact which an investigation alone has on individuals who are subject to the investigation. I mean, even without going into people spending time in jail, right? I mean, the effect of a competition investigation and possibly the finding of an infringement is profound. And at least in Europe, gone are the days when companies would actually graciously pay the fine for the individual involved in the price fixing. Or sort of, you know, sort of these individuals would then be sent to perhaps faraway places to head the sales department in Russia for a year or two. But those days are gone, and especially sort of public companies simply can't afford that sort of behavior anymore.
We need more time, probably. In the case of Japan, for the individual liability, we don't have the system like it in India, recently introduced, like go up to the management. Only the person who actually involved in the price fixing and etc. Actual conduct. But the authority would like to go higher and higher to catch the highest person who may know that kind of situation. In Japan, only a kind of serious case that there's a criminal sanction on an individual. In the past, there's no, actual service case, but it's theoretically it always does. So it's a kind of huge impact that the individual will be criminally liable or not. It is a really kind of important matter for the company. And even though there's no system for to go up to the, only the management, for the responsibility of supervising the people around you. There's no provision in a competition law and in the Anti-Monopoly Act. But in terms of reality, the shareholders' derivative action under the corporate law, it's kind of working as a measure to reinforce that function. In a shareholder derivative lawsuit, the board of directors, even though they knew about that or not, you should be liable in terms of, making a kind of damage of the company. And no insurance on that. I mean, basically for the shareholder derivative suit is wholly covered by insurance, D&O insurance, but not for this cartel things.
Drew, quick question to you. If an Indian company had operations in the US, what's the level of individual liability they're looking at?
Well, I mean, I think even before answering that, I would say you certainly don't have to have operations in the U.S. to be worried about it. I mean, as Indian firms become much more part of the global economy and are, selling directly into the U.S. from India, have lots of contact with suppliers in the U.S. and customers in the U.S., those laws will reach out and catch you, even sitting here, sitting in Bangalore. You certainly don't need to be sitting in New Jersey to have that kind of impact. And the on the books, theoretically, you could spend 10 years in prison. Now, no one's ever spent 10 years in prison for this, but I think the average sentence in the U.S. now is around 24 months. Yeah, and so 2 years in jail. It's a huge lever for the Department of Justice when they, obviously when they can get an individual in a room, in an investigation and say, you aren't going to see your children for 2 years, you're not going to go home for 2 years. In the old days, people would deal with this in one of two ways. The traditional Japanese way to deal with this was to create cartels that explicitly excluded the U.S. So we're going to set prices for the entire world except for the U.S. We're not going to do the U.S. And this is particularly true, or used to be for China. People would just say, well, and we just won't go to the U.S. Right? We'll just won't go to the U.S. And so it won't be a problem. The U.S. has now successfully extradited its first, I think it was a German national, to now serve time in the U.S. The U.S. is being quite aggressive about individual jail time for people at the highest level that it can pen that sort of cartel crime to. So, it doesn't matter where you are in the world, that is something that you need to be absolutely aware of.
On that note, we're literally out of time, and it's great that the Indian competition law looks good when we compare it to US competition law, but a quick roundup, and up to anyone, what's the one change you'd like to see in the Indian competition law?
Well, I was waiting for this question. Thank you, Nisha. No, well, in a various forum I've spoken on this subject, and repeatedly I keep on saying that when you borrow something from other country, don't borrow blindly. We have borrowed this law from Europe and some provisions from the USA, but fundamentally forgot that when you borrow something, you have to customize for your Indian culture, Indian maturity level, and towards that context, few wish lists I would say that more guidelines should come from regulatory, like penalty guidelines. And one more point which in one of the forum I mentioned, and today again and again coming to my mind and heart, that if you don't want to eat a toilet paper as a GC, you should go for the legal privilege communication protection. Otherwise, after running entire compliance program in-house, the first target will be you as a GC, that all the papers, all this laptop will be with you, and you are the only person in an organization who knows everything about non-compliances, and you'll be targeted. So I think it's required to lobby for the legal privilege communications to GC also, in-house GC I mean to say, which is there in the USA, I think, which is not in India. That is the one thing. Second thing, some of the protections given to US law for the patent and these things, the law of patent protection given in the USA, in India, and Europe is completely different. So exemptions, statutory exemption for JV, for patentability and all, is not in India. It's very, very strict patentability, while in liberty is there in the USA. So this comparison has to be properly required for JV exemptions out of this thing. And third, about criminal liability, which I would say, thankfully we don't have that so far, and it's not in my wish list. Thank you.
I think in the interest of time, I'll just make it quick. I think my expectation is that the CCI becomes more judicious, and as Kanaya mentioned, that there are some guidelines which is the need of the hour, and we need those guidelines for penalty, for individual liabilities, for cartelization related matters as such. Relevant turnover, absolutely.
Echoing sort of the request for more guidance, even if the authority doesn't have decades of administrative practice to back them up, issue them, keep to them, and revise them if you think they haven't worked as you thought they should. But don't leave the business community guessing.
Yeah, and a very simple thing that takes a long time for the procedural things and the whole process. So the cartel cases starting in 6 or 7 years ago, still continuing. So it's I don't know how to improve it, but that's what one of the wish list.
Yeah, and then just to go back to something we discussed earlier, but this absolutely goes back to what Kanai and Kaizal were saying. You have to have the trust of the business community if you are the regulator. The CCI needs to understand that we ask for more guidelines, we ask for more certainty. Without those things, without the ability for a business to make a business decision, an informed business decision about leniency, about how to respond to the CCI, what to do, they will not get cooperation. And if they do not get cooperation, I know in the US at the moment, more than 80% of cases result from leniency applications. I think it's similar in the European Commission. People will not use the program. People do not use the program in China. They only go in once they've been caught. If you actually want to break up cartels, before you get the ability to do that, you have to have that level of trust. And I think that underpins everything that the regulator needs to do.
Thank you for being such a patient audience, and thank you for this terrific